The First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Good afternoon. We have 3 cases scheduled for oral argument this afternoon. Our first 2 have been consolidated for purposes of the oral argument. The first 2 are Florida Department of Commerce, Revenue versus 1701 Collins Miami owner. And the second case is 1701 Collins Miami owner versus Florida Department of Revenue. We've allotted 20 minutes per side for the oral argument. Counsel, are you prepared and ready to go?
Yes, Your Honor.
Would you like to reserve some time for rebuttal?
Yes, Your Honor. 5 minutes, please.
So noted. You may continue.
May it please the court, Mark Urban on behalf of the Florida Department of Revenue. This is a consolidated action, and I'm going to try my best to go in order of the refund case and the rule challenge. But before I do that, I want to explain our legal position because I think it's dispositive of the issues in both cases. Documentary stamp tax is based on consideration. Consideration by definition is formed through mutual agreement. This agreement requirement of the term consideration is consistent with long-standing and well-known common law and dictionary definitions of the term. The ALJ in this case agreed with this plain meaning of consideration, having defined it in his recommended order as the product of mutual assent between contracting parties. And even 1701 in this case seemingly does not dispute this plain meaning of consideration. Yet despite this agreement amongst the authority and despite this agreement amongst the parties to this case, 1701 asserts that the $77 million valuation from the deal pricing analysis is the consideration for the real property in this case. But because it wasn't agreed to between the contracting parties, it's not consideration and cannot form the basis for the tax in this case. And that position is based not only on the plain meaning of consideration, but also on controlling precedent. And the Florida Supreme Court in Culbreth v. Reed said that the terms consideration and valuation are not interchangeable in the taxing statute in this respect. And this court in Ray Construction brought even more clarity to that point. In the court's holding, they said when property is transferred for money only, like it was in this case, then there's no occasion to resort to an outside valuation. And I think that Ray Construction is really a reversal of the roles from this case. And so I think it's instructive to look at Ray Construction to see, what would happen if the department tried to do what 1701 wants to do in this case.
Well, counsel, if I could ask you a question, it seems to me the department's position is pretty clear, which is that if the parties agree to say $125 million to purchase some property and there's no allocation, well, we're going to have the tax on the $125 million. But then you seem to suggest, well, if the parties had stipulated as to an allocation, let's say in this case they stipulated that the real property was worth $25 million and the personal property was $100 million, that's dispositive to the department as well. So, but then it seems also further the department doesn't want to consider any evidence except that predated the actual transaction. So help me better understand the department's policy.
And I think that that's described, and I'll say that the department's position is that this is a restatement of the law. And I think that, as I mentioned in Ray Construction, that's sort of a role reversal. The department in that case, the property was exchanged for monetary consideration in that case. I think it was $6,000. And the department in that case said, well, look, you know, we're going to assess an additional tax above and beyond that $6,000, seemingly because they thought it was too low, based on evaluation. And this court, Ray Construction, said, no, you can't do that.
Okay, so if the party stipulated in this case that the value of the real property was $20 million, say $25 million, and the remainder of the personal is $100 million, the department has no authority to come in and say, whoa, wait a minute, that's not the correct valuation, that's not the correct consideration. We know that really that's not accurate. You have to live by what the parties stipulate to?
I think that that's what Ray Construction tells us. And I can tell you that there are incentives to not structure a deal whereby the real property isn't valued or isn't exchanged for, in other words, let me put it this way, there are incentives to not, for attributing $125 million to the real property in this case, and not attributing consideration to the other property types in this case.
Well, what if the parties had an agreement like they had here, which they were supposed to allocate, they didn't get around to doing it for whatever reason? But let's say 6-9 months later, they commission a study exactly like the one in the record of this case, and then they agreed to that. In other words, they agreed to $77.8 million for the real property. Is the department going to object to that?
Well, by rule and by statute, the tax attaches and is due prior to recordation. So it sounds like, Judge Makar, in your hypothetical, this would be an agreement post transfer of the property. And in which case, I think the department would be well within their right to deny the refund in that case because the agreement happened post the taxes attaching.
Well, I think you've clarified to me, which is nothing the parties can do post-transaction can undo the assessment that the department claims is due on the entire amount paid in consideration.
Well, I don't think, and I think maybe the question that you may be getting at is that, and I think a point that 1701 made in their briefing is that, look, you're making it so that we can never seek a refund. And I don't think that's the case. I think that there are perfectly valid reasons to that the department would grant a refund in this case. For instance, but through basis of a mistake. For instance, if the parties had agreed prior to transfer of the deed that, hey, look, we're going to attribute $77 million to the real property in this case. But then 1701 went ahead and paid on the $125 million. And then later on down the road said, hey, look, we made a mistake. That is a mistake. And I think in that situation, the department would say, yes, a refund is allowed in that situation.
Counsel, as a background question, could you explain the process of stamp tax assessment? Specifically, how did the stamp tax come to be assessed on the purchase price of $125 million when the deed reflected a consideration of $10?
Well, the stamp tax is paid, was paid by 1701 in this case. And there is an administrative rule that you can look beyond the deed or outside of the deed when nominal consideration, such as $10, is for that deed. But there's nothing that suggests, like 1701 argues in this case, that you can look beyond the operative deed or the operative statute to extrinsic evidence beyond that to establish what the consideration was. And not only that, the purpose of looking to extrinsic evidence is still to establish the agreed upon consideration. The tax is based on agreed upon consideration. So looking beyond the deed or the contract in this case is still for the limited purpose of determining the agreed upon consideration. Nothing about looking to extrinsic evidence allows 1701 to substitute a valuation that wasn't agreed to for consideration as the basis for the tax.
So what the department's policy that you've laid out now, is there a statute you're linking this to, or is there some rulemaking proceeding, or how would someone know if they're trying to get a refund? The day after the transaction's over, say, oh, whoops, we forgot to do the allocation. Well, the department says, well, tough, you didn't do it before, you can't do it now. Where does that come from? Because wouldn't you agree that in a case like this, there is millions of dollars of property that's being taxed that shouldn't be taxed?
The pursuant to section 201.01, the tax is to be paid prior to recordation. And pursuant to rule 12B4.0111 sub 1, the tax attaches at the time the deed is delivered. And respectfully, Judge Makar, I disagree with the assertion that tax wasn't supposed to be paid on the $125 million in this particular case. I think that the evidence, the competent evidence, shows that that was the intent of the parties. The tax was actually paid on $125 million being attributed to the real property. The settlement statement identifies $125 million as being attributed to the real property. So too does the title insurance. And not to mention the 1701's corporate representative testified that it's entirely possible, he didn't know whether it happened or not, that the parties intended for the $125 million to be attributed to the real property. So I think it's contrary to the evidence that this was for anything but $125 million.
Counsel, to be clear, did the department take the position both before and during the hearing that it denied appellee's refund application in part because the allocation of consideration was not established prior to transfer?
I can't recall if that was in the notice of decision or not, but as it was relayed at the hearing, the position of the department was that timing wasn't necessarily an issue in this case. And that's because we don't have the first element, and that is an agreement. So determine in this particular case, so in determining when an agreement happened is really immaterial. We don't have an agreement in the first place. The documentary stamp tax is based on consideration. Consideration is formed through mutual agreement. And if we don't have that agreement, then there's really no use in determining at what point in time did that agreement not happen, if that makes sense. And the next thing I'll mention is that I think we're sort of getting into this point, is that even if the consideration in this case were determined to be undifferentiated, or that the parties never actually split up the consideration amongst the property types. This court's holding in Cohen-Adger says that when taxable and non-taxable items are indistinguishable in the contract price, then the tax is still due on that full $125 million. So that would, assuming the consideration in this case was undifferentiated, Cohen-Adger would kick in. And there's that holding is consistent with the statutory basis for the tax. By statute, stamp tax is due on documents that convey an interest in real property.
But counsel, but what you're saying though overlooks that there's a refund process in which taxpayers are allowed to differentiate and show the real estate value versus the property, personal property, and so forth. Aren't you overlooking that?
Respectfully, Judge Makar, I don't know that is an accurate reflection of the law, and it sort of does what 1701 wants to do in this case, and to substitute a valuation for consideration as the taxable base. Just because something has value, it doesn't mean that the parties in their arm's length negotiations must or have to attribute consideration to that. And so I think that conflates value and consideration. The term consideration is in the taxing statute, not valuation. And so I think if the legislature had intended for stamp tax to be based on a fair market value or some other valuation for that matter, that they would have said so. And they didn't in this case.
Counsel, will you please explain the department's reason for finding that the reliability of the DPA, that is the deal price analysis methodology, was not established?
I think Judge Lewis, your question gets into sort of the Daubert inquiry, and in that situation, Ms. Dowell this is a proprietary method. Ms. Dowell is its only known user. And not to mention that Ms. Dowell is based a lot of this methodology on her own discretion. Not only that, the deal pricing analysis was not subjected to any peer-reviewed publication, nor was any measurable reliability testing done on it. And the last thing I'll mention is that it's not the generally accepted method in the industry. And so, and just to add to that as well, Ms. Dowell either testified to, or this was included in some of the articles that she had written, first that separating the intangibles or giving value to the intangible personal property, which is a core component of her methodology, by the way, is not typically something that folks in the industry want to do. They don't want to value intangibles. The next thing Ms. Dowell mentioned in one of her articles is that most in the industry subscribe to the management fee approach, which does not, unlike her methodology, give a value or give a value to the intangible personal property. Lastly, Ms.
Counsel, you just made the statement that her methodology is nowhere that it's not established in the industry. Where's that in the record? Did the department put in some expert testimony about methodologies?
The department didn't, but my contention on that is based on her testimony. She, and this is the last point I'll make on that, she mentioned in her article that's in the record that there is no recognized standard for separating the intangible value from the real property. And that's exactly what her methodology does, is to separate the intangibles from the real property.
Counsel, assuming for the sake of argument that we find the Daubert standard does not apply in administrative proceedings, but uphold the denial of appellant's refund, what is the proper disposition of the case on appeal?
Judge Lewis, I missed the last part of your question.
I'll repeat the question. Assume for the sake of argument that we find that the Daubert standard does not apply in administrative proceedings, but we uphold the denial of appellant's refund claim. What is the proper disposition of this case on appeal?
If Daubert does not apply, but you uphold the refund denial, Daubert is sort of an alternative argument in this case, and so we are saying that the refund was rightfully denied based on the statutes, based on the controlling precedent. But if the court decides to dismiss that controlling precedent, not follow that controlling precedent, not follow the law, then the DPA is not reliable evidence under the Daubert standard.
Thank you. You are well in your rebuttal time. However, we will extend your rebuttal time by an additional 3 minutes, and we're staying opposing counsel's argument by an additional 3 minutes as well.
Thank you, Your Honor.
Thank you, Your Honor. This is James McCauley appearing on behalf of 1701.
Mr. Cawley, since you are the appellant In the second case, would
Yes,
you like
sir.
to reserve some time for rebuttal as well?
I would like to reserve 3 minutes for rebuttal.
So noted. You may continue, Mr. McCauley.
Thank you. I listened carefully to some of the judge's questions. And of course, in preparing, I had prepared my own statements of how this case should be seen. I will go over some details, but before I do, I will give you a bottom line, if you will, that was tied to the judge's questions. As I had written down that a taxpayer cannot ask for a refund if you don't assign values prior to the time of the transfer of a deed. Essentially, they have cut off rights to a refund under Chapter 215 with respect to documentary stamp taxes when paid in error. There's findings of fact and both the recommended order and the final order. And indeed, counsel could not remember one of the questions of whether or not the NOD discussed something. I will read to the court from page 9 of the recommended order, paragraph 13, which is a statement that is included from the notice of decision. That is the notice of decision written in the denial in this case. So it says, there is no item, this is not, I am taking part of this out of this, and I could read the whole thing, but it is in the findings of the judge. There is no itemization of personal property. If there is no itemization of personal property, then the sales price is deemed to be consideration paid for the real property. So what the administrative law judge found, one, that this is their reasoning. This same reasoning is found in documents that were put in the record, TAAs, over a period of 5 years, each of which said you can agree to assign consideration to tangible and intangible property as long as you do it before a deed transfer. That's their position. Now, there is no statute, there is no rule that allows for that. There is absolutely no basis for what they have done. Now, I will point out,
Counselor, if I could, I think if I understand the case correctly, the basis for what they've done is that they say consideration is the governing principle, and from consideration, it has to be paid at the time of the transaction. And that's all they have. That's all the law addresses. So therefore, all these principles that they're laying out flow from that requirement of consideration.
there is a requirement of consideration. This is a taxing statute. The consideration that is taxed is an excise tax, and the consideration is on the transfer of real property. The facts in this case, as you stated, Your Honor, to counsel, there's millions of dollars that are getting taxed here that are not taxable. And the reason you stated that question, isn't that true? Because it is true, is that there's undisputed facts and there's lots of evidence in the record besides the testimony of Ms. Dowell that there were three kinds of property: intangible property, personality, this is a hotel that was exchanged, and real property. Two of those three are not taxable. So the ALJ looked at the petition and determined that there was an unadopted rule. That unadopted rule was determined because of the simple fact that there's nothing in the rule about this. And there is a rule, as counsel related to, that if the face of a deed only contains nominal consideration, that you're able to prove up or show up the amount of consideration. How could that not be done but after the fact?
Counsel, in response to the department's argument concerning standing, your standing in the unadopted rule challenge proceedings, what is the applicable test for standing in this case?
the applicable test for standing is whether you're substantially affected by the decision of the agency, whether in effect what is going to happen as a result of your decision affects your interest. That's the substantial interest test. And there is a substantial interest obviously here because, and I'll get to what the ALJ said about this, but it's obvious that they're standing to challenge whether or not you overpaid tax. That's the point of Section 215 of Florida statutes, to give somebody a right of entry to seek a refund. Otherwise, you cut off a backward-looking constitutional right to remedy an overpayment of tax. That is the exact point of Chapter 215, 26.
As a follow-up to Judge Makar's question, do you agree that in order to be entitled to the requested tax refund, appellant had to prove that it overpaid tax on the consideration for the transfer of real property?
I'm not sure I heard you correct, Your Honor, but I think the answer is yes. Could you repeat the question to me, though? I didn't.
Again, as a follow-up to Judge Makar's question,
Yes.
Do you agree that in order to be entitled to the requested tax refund, appellant had to prove that it overpaid tax on the consideration for the transfer of real property?
I believe that there is a right to a refund under 215-26, and that in going to a hearing, and the statutes allow you to go to DOE or circuit court, that you can seek a refund of taxes paid. You can do this by putting on evidence what the consideration was. If the deed has been recorded and is only a nominal shown on the face of it, consideration must be shown by evidence external to the deed. And I agree, you must demonstrate that consideration was paid. But the consideration to be paid is only consideration because this is a taxing statute narrowly construed on the real property, not on intangible property and personal property, especially when there's no dispute of fact that those exist here, and there's no statute or rule that says you can deny a refund based on essentially an irrebuttable presumption, which of course we've argued in our briefs that, and the judge himself made an observation that the law doesn't allow for the creation of administrative irrebuttable presumption. And so what you have is a case here that started out with usurpation of the legislative authority. The judge, ALJ, said this isn't just an unadopted rule, this is legislating. So they started out by denying a refund based on legislating, and they ended up defending what they did by usurping the judge's role and by reversing a recommended order and excluding numerous findings of fact, and they actually got into the business of weighing evidence in the way they styled their rejections.
Well, counsel, if I could ask you a question, I've been a lawyer for over 3 decades, and a lot of it I've done in administrative law. I'm not sure I've ever seen an agency essentially reject almost everything. I mean, I think there's something on the order of 70 exceptions, and every one of them, maybe I'm missing one, was not granted, but essentially bulldoze the order in its entirety. And,
exactly.
Am I incorrect on that?
No, you are correct. In fact, I would like to say it would appear that the agency and the judge were at 2 different hearings, and the agency literally overrode dozens of findings of fact. And I would say, for example, there were evidentiary rulings that said there was a finding that there were 3 types of property that made up the $125,000. They struck that. It's the final order, page 7 of the final order. Those are findings of fact. At another place, they got into evidentiary ruling, which is why I call this a situation where they strayed into essentially the quasi-judicial branch or judicial branch. They made a ruling saying the deal pricing analysis was inadmissible. That's what their ruling is. It can't be ruled on by the agency that something is inadmissible when there's competent, substantial evidence, and that's the standard for them to reverse a finding of fact. There was competent, substantial evidence to say the deal pricing analysis was persuasive. The department put on none, zip evidence that would show that the deal pricing analysis was not persuasive.
In regards to the DPA, that is deal price analysis.
Yes, sir.
What record evidence is there on it to establish the reliability of the DPA?
There is there's a bill of sale, and there's some other documents in the record, and there's testimony by the witness for the company. So there's testimony by a witness from the company. There's the bill of sale, and there's things like this that are available beyond what the ALJ found as a finding.
Regarding those documents,
Dowell. Yes, Your Honor, separate from Ms. Dowell's testimony.
Thank you. Regarding those documents, still yet, is there any evidence showing that the DPA can be or has been tested, whether the error rates can be and have been determined, or whether the methodology is generally accepted as reliable in the relevant scientific community?
Yes, there was testimony about it. The witness that was determined to be persuasive, Ms. Dowell, had an undergraduate degree in finance, a graduate degree, master's degree in finance, had worked for hotel properties, and had done an analysis like this numerous times. The judge found that persuasive.
Well, it says she'd done it 1,000 times.
I said numerous, Your Honor, because I don't recall if it was 1,000 or 500. She did it numerous times.
And she's been doing it for 30 years.
Yes, and she's been doing it for 30 years. So her testimony was very reliable. And there was no other, as the judge pointed out below, there was no expert put up by the department to say that this kind of testimony is improper or unreliable. There's just simple legal argument from counsel. And the bottom line, which is what I started out with, is that they have the DPA. They have the irrebuttable presumption. And that's all they did. They relied on that to reject a valid request to prove what the consideration that was not recorded on the face of the deed was for real property, and how much was attributable to intangible property and so forth. And that was done through discounting analysis and financial flow of money. And that was found in the judge's order below as well, and accepted that. And that kind of analysis, I can make legal argument too. I happen to be an accountant, but that kind of discounted cash flow is commonly used in finance. But I wasn't called to testify. There's no need for it. We had a valid expert witness.
Counsel, would Ms. Dowell's opinions and the figures produced by the DPA be the same without the pro forma projections?
Honestly, Your Honor, I can't say for sure that they would or they wouldn't, because I do know she evaluated the evidence that was there, the bills of sale, the documentation as to the different types of property, and then used that and then made some analysis that essentially discounted cash flows over time to associate a certain amount with real property and so forth and so on, intangible property. So I don't know that I can answer your question, but I would answer it that there is good reason to rely on the evidence that was in the record, and the finder of fact determined that. And there is no basis for saying anything but that in the record, because there was no other testimony in rejecting these findings of fact with respect to the deal pricing analysis. The deal pricing analysis was available, and it's discussed in the order by the administrative law judge.
Counsel, if I ask a quick factual question, it's not in my mind clear. This property appears to be either oceanfront or very close to oceanfront, and involves, it looks to be, I assume, some type of multi-story hotel.
Yes.
And maybe some amenities. Is that what we're talking about?
Yes, it's a hotel. It's on Collins. It's 1701 Collins. Yeah. I have not been to it, but I have to assume it's on Collins Avenue, which runs right near the beach. Yes, I don't know the exact, and I don't know if there was any testimony in the record as to its physical location. It is in Dade County. There was some records about from the Dade County tax returns on ad valorem and so forth. But so it's in Dade County. Collins Avenue is on the beach. It's a hotel.
Do we know how many floors? I mean, is it 2 stories or 20
stories? I honestly can't answer that question, Your Honor.
I mean, it would matter on the real estate evaluation.
Well, I mean, it had realty, it had personality, and of course, because it was a intangible value, there was value associated with goodwill, or when an accounting treatment is associated with non-tangible value. And that's what the deal pricing analysis attempted to split off and discount through the method used.
If I could clarify, there's no side agreements where they sold personal property separately, or there's no side agreement where they sold the trademarks or logos or goodwill. It's all
not to my knowledge.
It's the 125 million price for the whole bundle of properties.
That's accurate to the best of my knowledge, Your Honor. Yes.
Counsel, I got a question for you. So the statute tells the state to tax the consideration. The DPA purports to identify the value of the real property that was transferred. Can you tell me how you make the connection between the value and the consideration that is due under the statute? What evidence is it to link those, to turn the valuation into consideration?
The consideration, there was a contract which anticipated separating these different assets out, but it did not occur before the sale occurred. That's part of the answer. The other part of your answer, to my knowledge, is that because there was only nominal consideration on the face of the deed and the tax had been paid on the full amount, that there is no limitation in the kind of evidence, so long as it's relevant evidence and judged by a trier of fact, which there was in this case, to tie the amounts associated or values, which is what you observed, Your Honor, to consideration. Because consideration did occur. Obviously, it was a arm's length transaction, but the consideration occurred for the total, for all the bundle of rights and interests, and the value is intended to associate parts of that total consideration with the underlying assets. That is the connection there. There can't be any other connection because there was nothing done beforehand. It was done after, although it was anticipated, as I said, that there was going to be done.
So the idea is that we would, or the trier of fact would infer the amount of the consideration from the value that was identified in the DPA.
Yeah, exactly. I wouldn't disagree with that characterization.
And the consideration is consideration for the real estate. I mean, the statute talks about the real property. This is a documentary stamp tax. It's not a consumption task. So the consideration has to be the consideration for the real property. So it seemed to me what the ALJ did made some sense to me, at least, which was to say there's a distinction between contractual consideration, which is not what the statute says, but there's consideration for this purchase of the real estate.
Yes, Your Honor. And
taxable consideration.
I'm sorry, I started to speak over you.
That's okay. I don't know. I spoke over you. I was going to say the taxable consideration.
Yes, it is. I completely agree with what you just said. There's 2 points that run off of what you said I'd like to make. One, it is taxable consideration. This is a taxing statute. The case law is clear. This is narrowly construed. The other is the consideration it was demonstrated after the fact, as I just answered Judge Long's question. But the amount of consideration has to be able to be demonstrated as overpaid. That's the point of 215-26. And once consideration, when it's not on the face of the deed, the department's own rule, which counsel acknowledged, you can look beyond the deed for consideration when there is only nominal consideration recited on the deed. And that's very common in practice. It's more common that occurs than anything else. There's also no requirement for mutuality in the statute. And there's nothing in the statute that says, as you observed, Your Honor, contractual consideration. That's
Counselor,
not
you're well into your rebuttal time.
Okay. I will stop talking then.
I'm going to start off with sort of the last questions that were made. And so this inference that we need to allocate because these other properties have value, that is directly foreclosed by this court in their precedent and by the statute. And let me explain that. This court's holding in Cohen-Adger was that when taxable and non-taxable items are indistinguishable in the contract price, that the tax is due on the full amount of contract price, the full amount of the contract price. Applying that to this case, assuming this consideration was undifferentiated, the parties just didn't do it, the tax would be still due on the full contract price of $125 million.
Yeah, but counsel, that goes back to my question when you were up there before. There's a refund process to sort these things out.
Okay, and I agree that there is, but that gets back to consideration. Consideration is required to be agreed to. At this point in time, we don't have any input from the other party to this contract. So what's missing is consideration. So we can't base this refund on a valuation. I mean, that is statutorily the documentary stamp tax is due on consideration, not on evaluation. And I want to point to Ray Construction again, because I think Ray Construction is really instructive. What would happen if the department tried to do what 1701 wants to do in this case? In Ray Construction, they sold the property for $6,000. The department, apparently thinking that was too low of an amount for the real property, tried to assess an additional tax based on evaluation. This court said, no, you can't do that. There's no occasion to resort to evaluation. They're essentially, to go back to your question before, Judge Maycar, yeah, they're stuck with it. They're stuck with it. And so my point is, just because something has value doesn't mean the parties are required to attribute consideration to it. It's conflating the terms valuation and consideration. Not only that,
but in this case, wouldn't you have to concede I think it's, you'd have to concede that the 125,000 included real property, personal property, and intangible property, the whole ball of wax, the entire hotel operations.
Yes, I don't think we're disputing here. Well, we're not disputing here that those other items have some value. But again, that conflates value and consideration.
But then how are they going to show it other than by showing allocating the value or making an allocation among the quote consideration?
Show what, Your Honor? I'm not sure what the question. Show what the consideration was.
The allocation.
Well, there's really, I don't think there's really there isn't a requirement to allocate. And so I think the competent evidence shows that this was the allocation, that they wanted to keep $125 million attributed to the real property only. 1707.
But their evidence is entirely to the contrary.
1701 is saying today, and at hearing, obviously, that this was a mistake. But the competent evidence, in our view, shows otherwise. They paid tax based on $125 million being attributed to the real property. The settlement statement identifies $125 million being attributed to the real property. So too does the title insurance.
You're not claiming improper motive or that they're trying to commit a fraud. I mean, there's nothing along those lines, right? This is just a case where they think they have evidence that shows an allocation they want to refund.
That 1701 does. We don't know what the other party wants because the other party hasn't testified. They haven't told us what we want. We're looking at the evidence, and the evidence suggests that at the time this was not a mistake, that they fully intended to attribute $125 million to the real property only.
But then why did they have a clause in the contract that said they were going to allocate it?
And it says you're required to, but there's nothing to suggest that they didn't agree to $125 million being attributed to the real property. There's no competent evidence to suggest otherwise.
Well, there's no evidence to suggest that they did. I mean, do you have some evidence of that?
That's when we resort to Cohen-Adger, this court's precedent in Cohen-Adger. If the consideration is undifferentiated in the contract, the full $125 million is what the tax is due on. And so just in some, looks like I'm out of time, so I'll just summarize.
You may wrap up, counsel.
The department relied on controlling precedent in the plain meaning of consideration in this case. So we ask that you affirm the final order in the refund case. We're also asking that in the rule challenge to vacate the final order and direct the ALJ to dismiss the petition because 1701 didn't have standing in that case, and because the ALJ reformulated the statement and exceeded its authority in doing so, didn't have jurisdiction to do that.
Thank you, counsel.
If it please the court, I would like a few minutes I reserved. I'd like to use those now.
It appears that you have 46 seconds, counsel, left.
Okay, there is no controlling precedent in this case. Cohen-Adger is a case where there was a secondary deed, not one deed, and that separate deed was between two parties that were owned by the same people. It is completely unrelated to this, and that this was an exemption case. This is a taxing case, and it was not a refund case. Likewise, the other case that is cited by counsel, which is Ray Construction, Ray Construction was between two parties that were controlled by the same entity. That was an exemption case. Cohen-Adger was some property that was deeded from the city to the developer. They built a building on it. There's no evidence there's other kinds of property involved, and they deeded it back when the construction was done. It is completely distinguishable from this case. And the third of these so-called controlling precedents is called Cuthbert, where that is a deed for love between, the court simply said, there's no consideration here whatsoever because these are related parties. It's a deed to a father, to a son, or a family relationship. Otherwise, completely distinguishable. That's all I have to say.
Thank you, counsels, for your respective oral arguments. This
Thank
concludes
you.
our oral arguments in our first two cases consolidated for purposes of the oral argument.
Thank you, Your Honors.
Good afternoon. Our final case scheduled for oral argument this afternoon is Florida Carry Inc. versus John Thrasher, an individual, and Florida State University, case number 20-412. We have reserved 15 minutes per side for the oral argument. Counsel, would you like to reserve some time for rebuttal? I don't think we can hear you. I'm sorry, counsel, we didn't hear you. How many minutes would you like to reserve for rebuttal? Apparently, we are having problems with the audio. We can't hear you. Hear counsel. I think we can hear you now. You may proceed.
Mr. Friday, we're continuing to having some audio issues. Would it be possible for you to join the audio portion via a standard phone? Your Honors, I'm going to place you briefly back in the waiting room, and we will do a brief troubleshooting with Mr. Friday.
I switched to a different mic. Does that have me now?
Yes, sir. Thank you.
Thank you. My apologies. I'll try again. Eric Friday on behalf of the appellants, Your Honor, and I would ask to reserve 3 minutes for rebuttal.
So noted, counsel. You may continue.
Thank you, Your Honor. Your Honor, the issue on this appeal is a very narrow one initially. Whether an organization bringing an action to enforce the provisions of Florida's Firearms Preemption Statute is required to exhaust administrative remedies prior to bringing an action in circuit court as specifically authorized by the statute. The statute says bring an action to enforce this in a court. It doesn't say before a hearing officer. It doesn't say before the agency. Despite that clear language of the statute, the defendants here argued to the trial court and convinced the trial court that there was some obligation to exhaust administrative remedies. Now, Your Honors, the reason we have a general principle, not a jurisdictional issue, in regard to exhaustion of administrative remedies are generally one of two reasons. The administrative agency's specialization in a particular field, which does not apply here where we're talking about a university and firearms issues. And secondly, to give an agency a chance to correct its actions. Normally, that might be an issue in many other agency actions. However, here, the agency knew full well what it was and was not allowed to regulate. We were already had a case involving the same parties about the regulation of firearms on campus. Then, while that case is pending before this court, they amend their own regulations to add ammunition, which is also preempted from regulation by the defendants. Now, they've argued that this should be res judicata. However, the timeline of these two cases between these two parties are that the first appeal of the first case was filed on July 29th, 2016. At that point, the trial court lost jurisdiction over the case, the issues between these parties. This court ruled and reversed the trial judge in part for further evidence on May 25th, 2018, and issued a mandate on June 15th, 2018. On 7/2, a motion for leave to amend was filed in that first case to add the ammunition component to the first case. The defendants objected. Now they want to come before this court and argue to this court that even though the trial court did not rule on the res judicata issue, that it should be res judicata because we had the opportunity to bring the ammunition issue before the trial court in the prior instance. We attempted to. Florida Carry, the plaintiffs, attempted to do just that. They objected, so here we are.
Isn't the ammunition issue off the table now?
No, they have argued that it is moot.
But isn't it out of the code?
It has now been taken out of the code, Your Honor, but it was only taken out of the code at some point well after the filing of the new case to address the ammunition issue. I believe their brief references, the new case was filed in August of 18. They withdrew it in September of 19, I believe is what their brief notes.
Is there any other substantive issue that would be pending in your view?
Your Honor, the only substantive issue would be whether or not a defendant, by withdrawing their violations of the law after the fact, should be immune from suit or should be able to moot the case. And Your Honor, I would actually point to a statement made by yourself in a concurrence in the UF case, where in your concurrence you wrote that prospective relief may be appropriate where it is shown that a recalcitrant defendant, despite ceasing its illegal action, is likely to return to its former ways. In this case, and in between these parties, this defendant, knowing full well that they had a plaintiff who would sue them for violating Florida's preemption law, turned around and added new provisions to the preemption. Their rules still are not clear in regards to the differentiation between handguns and long guns. Now, the statute doesn't use the term long guns in 790.25, which is the vehicle carry portion that they're violating by their regulation. The statute references any firearm other than a handgun, which colloquially is known as long guns, rifles and shotguns, which they attempted to require be concealed until that issue was raised. Frankly, Your Honor, I'm not even clear that they've removed that provision yet or not. But Your Honor, the mootness issue has become a theme in these type of litigation around the country. Perfect example would be the recent case out of before the U.S. Supreme Court, where they ruled April of 2020 that a case was possibly moot, maybe not. They remanded it to the lower court for further consideration. But in that case, the state of New York had litigated a case all the way to the U.S. Supreme Court before finally withdrawing their violations of firearms rights of individuals in order to avoid a ruling from the U.S. Supreme Court. We've seen this time and again in other cases where the rules are amended by this defendant in the midst of litigation in an attempt to continually moot and stop the ability of plaintiffs to get a final enforceable judgment against them to stop their illegal regulation of firearms rights.
Well, counsel, what do you make of the statute 1001.706 that gives the power to have the universities place restrictions on activities and on access to firearms?
I would say a few things, Your Honor. Number one, as to whether there's an open question whether or not the legislature improperly delegated that authority to the universities because of this court's holding in the UNF decision, where this court noted that Article 1, Section 8 precludes any agency of the state with the limited exceptions of things like FWC, who has its own constitutional authority to regulate firearms in certain aspects. Number two, Your Honor, I would say that it might be a allowable delegation to the extent that it regulates where guns are already allowed on campus by law. For example, firearms classes on campuses for law enforcement academies, that might be permissible. But third, Your Honor, 1,000 statute you referenced, 1001.706, does not, again, it allows them to regulate firearms but not ammunition, which is what one of the two issues in this case is. So even if the court finds that that statute is applicable as to the concealed, unconcealed nature, they would have to, number one, violate what the statute 790.25 specifically allows by the regulation they promulgated. And number two, that statute doesn't give them any authority over ammunition, which is one of the issues here. Your Honor, the legislature, having spoken and created a process for compensation for these violations, has created a cause of action. The legislature has determined what remedies should be available, creating a legislative determination of what is a sufficient remedy for these violations. But yet the defendants want to force the plaintiffs under administrative procedures where many of those remedies are not available. The remedy of a declaratory judgment is not available. Is not necessarily available, not from a circuit court. The remedy of injunctive relief may or may not be available. And the remedy of damages is generally not available in a proceeding under Chapter 120. More importantly, additionally, the right of attorney's fees is not mandated under a 120 action. And defendants make much of this in their answer brief and say that this is really all about attorney's fees. Well, there is a component of that because only private parties have the ability to enforce the firearms preemption provisions of Chapter 790. The legislature didn't choose to give that authority to the Attorney General. They didn't choose to give that authority to the local state's attorneys when an entity was violating the law. They gave it to private parties, and those private parties should be compensated as the legislature set forth when they bring these cases. Defendants say that the Falls Chase case, the Curry case, and the Winnick case are not applicable here. But they do not cite each of those cases stands for the simple proposition that where an agency has no authority in the first instance, there is no requirement to exhaust administrative remedies prior to bringing an action. While saying that those cases don't apply here, they don't set forth exactly why they don't apply, nor did they set forth any alternative case precedent that says there is some mandated requirement to pursue administrative remedies when an agency is acting outside of its legal authority and in violation of a preempted area of law. And for that reason, we would ask that this court reverse the court below and find that in the context of 790.33, there is no obligation to exhaust administrative remedies prior to bringing the suit allowed by the legislature. And unless there are any questions, Your Honors, I would ask to reserve the remainder of my time.
Mr. Friday,
Yes,
you don't contest that the legislature has lawfully set up a system or enacted a statute that allows universities to have this method of having substantially affected persons being able to be heard if they claim something's unlawful, right? You're not saying the legislature couldn't have given this authority to universities to have this system of resolving these disputes.
The legislature presumptively could have given administrative agencies, universities or otherwise, the authority to require a person to give notice, for example. Similar issue was raised, I believe, by these defendants. I don't believe it came before the appellate court, was raised in the UF case, arguing that sovereign immunity statute was applicable to actions under 790.33. And this court rejected that argument. So had the legislature chosen to put in some type of pre-suit notice or some type of administrative remedy attempt prior to bringing a lawsuit, under 790-33. That was well within the power of the legislature. They know how to do it. There are many other things like medical malpractice, sovereign immunity that do require certain pre-suit notice or investigation procedures. And the legislature didn't include any of those in these cases.
Well, in your statute 790, you're saying?
Yes, sir.
Yeah, but you're not contesting the authority under 1001-706 for the university to have this dispute resolution process.
The university can create a dispute resolution process, but Chapter 120 both speaks to the issue that nothing in its provisions takes away the power of a circuit court to render a declaratory judgment. And declaratory judgment is one of the specific remedies provided for in 790-33. And additionally, we would argue that because the preemption statute is the more recently enacted law, which was in fact the case, part of what this court relied upon in the UF decision, that the more recently enacted law controls. And while additionally, the more specific over the more general, while the universities can have a dispute resolution process for most of their code, I don't think it applies in an area like 790-33 unless the legislature requires it.
Counsel, you are into your rebuttal time.
I would ask to reserve the remainder, Your Honor.
Thank you. You may proceed, Mr. Richard.
May it please the court, Barry Richard on behalf of the appellees. Let me begin with the issue of whether or not the lower court erred by holding that the case had to be dismissed for failure to exhaust administrative remedies. Rarely do we have a requirement for administrative remedies as clearly set forth by the legislature in this case. As Your Honor, Judge Makar pointed out, Section 10,001-706 specifically provides the Board of Governors with the authority to delegate to the individual university boards of trustees the power to any of the powers held by the Board of Governors, and mandates, well, it provides that any such authority carries with it the authority to accept regulations, and mandates that those regulations must include a provision for any substantially affected person to challenge them in an administrative proceeding. Accordingly, FSU adopted a group of regulations that tracked pretty much completely the provisions of Chapter 120, authorizing anybody having being substantially affected to bring an administrative proceeding to challenge any regulation. The fact is that, and it provides in it that the administrative remedy must be exercised, it must be fully exercised before a case can be brought in court. FSU did that, and that provision that requires the exhaustion of administrative remedies, which was adopted in 2005, has never been challenged by anyone, including this plaintiff, and was not challenged, its validity was not challenged in this case. The only thing that plaintiff argues is that Section 790.33 states that any organization or individual affected can file a lawsuit in the circuit court, but that doesn't say anything about an exception to the requirement to exhaust administrative remedies. The fact is that there are many provisions, both in the Constitution and in statutes, providing for the empowerment of courts to hear cases and creating a standing for individuals to bring those cases. And they don't say anything one way or the other about exhaustion of administrative remedies. Nevertheless, this court and all other courts in Florida have required the exhaustion of administrative remedies. The effect of that is those cases that provide jurisdiction to a court don't have anything to do with whether or not you have to meet the requirements of exhaustion of administrative remedies. Now, counsel attempts to create an analogy to the case involving that held that the state's sovereign immunity statute, that the provision in it for notice wouldn't be waived. But what that case actually held was that it was only applicable to tort cases. And the case in which it was raised was not a tort case. And that's why the court reached that holding. It really has no analogy whatsoever to what we're dealing with here. This court in Department of Environmental Regulation versus Falls Chase held that only in exceptional cases may the courts assume jurisdiction to render declaratory and or injunctive relief without requiring exhaustion of administrative remedies. That's the law in Florida. Now, counsel argues that there is an exception, and that one of those exceptions is when a statute facially and clearly violates, or a regulation facially and clearly violates a statute. And they argue that for several reasons, the regulation in this case meets that exception. And that's what brings us to the substantive questions. And there are essentially four of them. One of them is the argument that 790.33 absolutely prohibits any agency from regulating firearms under any circumstances, but that's not what it says. As Your Honor, Judge Makar pointed out, the statute itself says that the authority that can be delegated to the universities by the Board of Governors includes, and I'm quoting it, the authority may include placing restrictions on firearms. That's very clear language. And the legislature has provided that authority. In addition to that, this court held in Florida Carey versus University of Florida, which incidentally was 3 years after the North Florida case, that a regulation that simply recognizes what the legislature has enacted is not a violation of the prohibition on passing regulations to begin with, whether or not they're authorized by the legislature. And as I'm going to point out when we discuss the next substantive issues, that's exactly what the regulation does. It tracks the language of the statute and nothing more. So the first argument that counsel makes is that the code, the student code, the regulation, doesn't allow unconcealed long guns. But the code again tracks the statutory language. 790.25 allows in a car on campus, quote, a concealed firearm or other weapon in the vehicle. It doesn't distinguish between handguns and long guns. It just says a concealed firearm within the car. Now, the fact is that the student code adopted in 2018 said that it only applied to a handgun that must be securely encased. So in fact, the code prior to 2019 was more restrictive than the statute was. In 2019, FSU amended its code to bring the language in line with the statute itself. And now it says exactly what the statute says, that it's lawful to, and I'm quoting from 790.25 subsection 5, possess a concealed firearm or other weapon if the weapon is securely encased or is otherwise not readily accessible for immediate use. This brings up the second thing that they're arguing, which is that the code requires long guns to be securely encased. Well, the fact is the code doesn't require it to be securely encased. It does what the statute does. It requires that it either be securely encased or that it be otherwise inaccessible for immediate use. That's what the statute says, and that's what the code says. And there is no long gun exception in the statute. And the third, well, actually, I'm sorry, but the fourth argument substantively that the plaintiffs make is that as counsel pointed out, the word ammunition was added to the statute, to the code. Let me point out, by the way, counsel suggests that FSU did this knowingly and intentionally. But if one looks at the history of the adoption of that provision, which is in the record, you will see that there was no indication that it was even being taken up by the Board of Trustees until the day it was taken up. It was not recommended by general counsel, and it was not in any of the prior iterations of the code. It appears to have slipped in because somebody thought it was a good idea just before it was presented to the Board of Regents, to the Board of Trustees. The moment that this lawsuit was filed, well, I say the moment, shortly after it was filed, and general counsel became aware of this, it was removed. And it was moot by the time it reached the court on the motion to dismiss, which is the important thing, and which is another reason that the lower court should be upheld. The fact that it was adopted after the lawsuit was filed is not the essential issue. It's that it became moot before the court dismissed the case, and there's no indication in the record or otherwise that FSU can be expected to readopt it at some later time. The moment they found out about it, they removed it. Let me mention one other thing, by the way, about this issue of ammunition, because it's not as clear as the plaintiffs make it out to be. Section 790.115, which prohibits firearms and destructive weapons on campus, defines destructive weapons to include ammunition. It's expressly defined to include ammunition. So the question then becomes whether when the word ammunition appears in the regulation, it is limited to destructive devices. Destructive devices are firearms, but there are also other devices, or not. Clearly, and the reason that FSU removed it is because you can't expect a person reading that code to know those kinds of nuances. But the fact is that it's not as clear as plaintiffs stated it is, because some ammunition is prohibited on campus. The reason I mention this is because this is precisely the reason, as this court has said among others, that we have a requirement to exhaust administrative revenues. If this case had been brought administratively, this could have been resolved easily. And this is the second time that this plaintiff or that this organization has sued FSU, and it also sued the University of Florida with no warning. The reason I mention that is because these cases could have been resolved with a phone call, and certainly could have been resolved with the exhaustion of administrative remedies. And in their brief, surprisingly, I believe, counsel has admitted that the reason they filed them is because they wanted the opportunity to obtain attorney's fees, and they didn't want to take the risk that exists administratively of having to pay attorney's fees. But that's no reason to impose upon the courts of this state, both at the trial level and at the appellate level, the time and the labor necessary to hear these kinds of arguments that could easily have been avoided.
Let me ask you one quick question. It's a hypothetical, but we can make it FSU, but make it any state university. Let's assume that there's a regulation that's been enacted and it's been on the books for a year or two, and it creates a protest zone. And let's say it's at FSU, and it's a 15 by 15 foot piece of the campus, and it's long ways from the main campus. Let's put it on the Seminole Golf Course. All right. So if you want to protest at FSU, you can go to the protest area. So let's say a national politician's coming into Tallahassee, is going to be on the FSU campus, and I want to protest him, and I'm an FSU student. The regulation says I've got to go to the golf course 5-6 miles away, and I can stand there and protest by myself. Isn't that a situation where how am I going? And let's say the event is tomorrow midday. How am I going to get a remedy out of the administrative process? Can I go to circuit court?
Oh, yes, and that's another exception to it. You can go directly to the circuit court if you have an exigent situation in which it's not practical. And one of the most frequent times that comes up is because number one, there's no time, and number two, it involves a fundamental issue, which here it involves the issue of First Amendment rights. And this very issue has come up, as Your Honor may know, when we had speakers who were very controversial wanting to come to campus, and the question became how far away from the campus can be set. But there's no question that if the administrative process doesn't provide an adequate opportunity for a person to have a remedy, that they can file directly in the circuit court. But that not only is not what happened here, nobody's even claiming that that happened here.
If you change the facts of this case and say, well, the regulation said you can't have a gun securely encased in your vehicle, and wouldn't that be a situation then where they could go to court and bypass the administrative process?
Well, there is an exception, as I mentioned, if the regulation is a clear and facial violation of a statute, but that's not the case here. Not only does it not violate the statute, it tracks the language of the statute with regard to most of the things that have been raised here.
Okay.
Unless there's further questions, Your Honor, I have nothing more.
Thank you, Mr. Richards. Counsel, the floor is yours.
Thank you, Your Honor. I must assume that Mr. Richard misspoke when I thought I heard him say that destructive device includes ammunition. 790-001 specifically states destructive device does not include shotgun shells, cartridges, or ammunition for firearms. The legislature has specifically excluded destructive devices or ammunition from the definition of destructive devices, and nothing in 790-115 prohibits ammunition on a campus, period. That's the black letter law. Secondly, while Mr. Richard claims that or argues that that the statute only addresses handguns, 790-25 sub 5 says, after the language he quotes, goes on to say, nothing herein contained prohibits the carrying of a legal firearm other than a handgun anywhere in a private conveyance when such firearm is being carried for a lawful use. The actual reason for that, Your Honors may be old enough as I am to remember gun racks in the back of pickup trucks. That's what that statute's about. That is a visible, open, easily seen firearm. It is not securely encased and it is not concealed because it's not a handgun and it's not required to be. The admission that the regulation at issue mostly tracks the language of the statute is exactly the problem. If the university would quit attempting to co-regulate in an express field preempted area that the legislature has told them not to regulate in, that the Florida Constitution tells them not to regulate in, and would just stay away from the issue, we wouldn't have these issues. There would be no need for administrative remedies. There would be no need for further litigation, but they just can't help themselves. They have decided that they just have to speak to the issue and that state law prohibiting firearms on campus with limited exceptions isn't enough. They have to put it in the student code of conduct too. They did so, they got sued. They amended, they had to be sued again. And Your Honors, that's why we're here today, as to whether or not the legislature has created a right to sue them without going through an administrative remedy first. Thank you.
And thank you, counsel, for your respective oral arguments. This concludes our oral arguments for this afternoon. We stand in recess.
Thank you, Your Honors.